All right, welcome everybody to the pre-Labor Day weekend edition of Legal Tech Week, the show where we talk about the top stories in legal tech and innovation that happened over the past week. And appreciate all of you who are here in the audience today instead of in your cars on the way to the beach or whatever else you might be doing. It might be some better things to do over Labor Day weekend, but at least on the Friday, this is a pretty good thing to do, I think. So let's get going with our find out who our panelists are today. And Stephanie, you want to kick us off?
Oh, sure. I wasn't expecting that, clearly. I am I'm on vacation, but I'm
I like to
here.
catch you off guard. What can I say?
I know. I'm like on vacation and very tired, but I'm here because I love y'all. I'm Stephanie Wilkins. I'm the editor-in-chief of Legal Tech News at ALM. Hi.
All right. Very tired from good things, I hope.
Yeah, just early flight, and I'm gonna take a nap as soon as this is done.
Okay. All right. And Victor, how about you?
Hi, everyone. My name is Victor Lee. I am assistant managing editor for the ABA Journal. Yeah, I don't really have any plans for the weekend. I'm sure something will come up, but yeah, nothing concrete.
Between dogs and kids, you'll find something to do.
Yeah, well, I'm sure the kid will be like, "Where are we going? What are we doing? Where are we going?" And I'll be like, "I don't know."
I like that. All right, Joe.
Joe Patrice from Above the Law and Thinking Like a Lawyer, the podcast. I am here and raring to go. This is a big. Technically, I guess there's a week 0, but this is the first real week of college football. So I'm raring to go. Very excited about that. I have already won a bet. Because of online gambling. So we're already ahead of the game.
All right, sounds good. And Niki.
My name is Niki Black. I'm the Principal Legal Insight Strategist for Finipay's legal side of the business, which is My Case, LawPay, DocketWise, and CaseFear. And I write legal technology columns for Above the Law, ABA Journal, and the Daily Record. And I am normally not in a rush to get this panel over with, but as soon as it's over with, I'm going to leave and go pick up a puppy. So I'm very
so
excited.
jealous. I'm so
It's
jealous.
going to be our third dog, like living. We have 11 and 13-year-old dogs, so my house is going to become a kennel. I'm turning into a
Oh,
crazy
wow.
lady.
What kind of dog?
She is a chocolate lab, and she's 8 weeks old, and her name is going to be Mochi.
Oh,
So
I currently have a dog here. I'm not a dog owner, but I do have a dog sitting behind me because people visiting brought their dogs.
dogs are the best.
Yeah, well, I was just telling Nikki, I'm not a dog owner either, but Ben, who our producer for the show, was home for much of the summer with his dog, who was actually a Instagram star. His Ben's girlfriend maintains an Instagram account about the dog, when kind of their traffic went through the roof when she put up this ambiguous post one week that people thought meant the dog had died, and everybody was really sad about it. And so like she had millions of hits to her Instagram account, and it turned out the dog is fine.
Yeah.
But
It was a
what's the
no-bones day.
What's the handle? What's the handle?
it's what is it? Chillin' with Buds, CHILLIN with BUDZ, I think it is something like that. But Buddy is his name.
That could go in a lot of ways, that chilling with buds.
Yeah,
That-
yeah.
Yeah.
It's been kind of dormant because she's been away this summer. But as a result, he was with us, and I got to do a lot of dog walking and dog sitting, and now I'm stalking the local animal shelter, thinking I want to get a dog. So
Well, anyway, thanks everybody for joining us for our pet podcast.
what else is there to talk? I mean, it's Labor Day weekend. Okay, well, all right. We can get to, actually, that's a good transition because, Joe, I know that you have really been kind of doggedly covering this really controversial issue in the legal tech world this week. And I see you even wore a shirt maybe more or less appropriate to that issue. So you want to tell us about that?
So there was a little blow up. Legal tech and lawyerly as a whole. There was a little bit of a blow up over social media as a managing partner of an outside general counsel firm, raised the comment that, if you're a lawyer on a video call, you should not be wearing a t-shirt. That was the statement. It received mostly negative feedback, as everyone piled on to be like, or you can be competent, then nobody would care about that. And he was very, he was not dogmatic about it. He would applaud the people who had that opinion.
Team call. I'm so excited.
Yeah. But yeah, no, and it became a legal tech issue because Nick Rishing jumped in on it and made a joke about it. But the whole conversation spilled over. More people were talking about, like, I don't meet people in t-shirt. I meet people in t-shirts all the time. No, I dress up. He says you should be able to dress up if you have $1,000, if you're charging $1,000 an hour. Became a whole deal. And it got me thinking, where are we on the issue of what you wear on video calls? And is this different than in-person meetings? Because I thought about it, like, obviously during the pandemic, we had, on this show, we talked a lot about some of the more embarrassing moments where people were naked in court hearings and stuff like that. But has that changed? And is there a new protocol for what people wear in those sorts of situations? I put this to the Twitterverse, and I'm still collecting results. So if people want to jump in and vote, they can. There's 5 days left in this poll. Right now, I will say that the majority of folks still believe in dress shirts. 60% of the voters think that dress shirt is enough. You don't need a tie, you don't need a suit, but you do need to be wearing a collared dress shirt. 27% believe a t-shirt is all that you need, and 6%, a lowly 6% say that you need a suit, and that is being beaten by a percent with 7% for tuxedo, which I did not think was going to get too many votes, but here we are.
I think this is really interesting. I mean, I think, I still practice law a little bit, not a lot, but it is constantly surprising to me how many people are casually dressed on fairly formal calls. And like I do lobbying, so I'll be testifying to the legislature. If I'm testifying to the legislature on Zoom, I'm going to put a suit and a tie on. But a lot of the legislators just have a sports coat on, or some of them are coming from their home in Zoom, and I've seen legislators in t-shirts while I'm, sitting there in my suit and tie testifying to them. But lots of other people come in and testify on an issue that maybe they're, some of them, I think for the most part, lawyers, when they're doing that, are going to put something decent on when it's a formal hearing like that. But many members of the public are welcome to come in and testify on bills, and it's t-shirts are pretty much the norm in a lot of these people. It's just a funny world right now.
Yeah, we had a court hearing that was done over Zoom right after we adopted our son. And so, I mean, I took it seriously. I wore, my suit and whatnot, but I was just like, okay, I'm going to be sitting the whole time. And I don't have a pair of dress pants that fit me anymore because I haven't worn a suit in like 5-6 years. So I was just like, okay, if I wear dark sweatpants with my jacket and tie, as long as I don't get up during the course of the call, even if I do, it'll blend in well enough that I think I can get away with it. So I did it and I got away with it. But yeah, no, I definitely understand sort of the impulse for this. Like, what is it, dress for the job you want, or dress for the job, clothes make the man, or whatever, or woman, whatever, like whatever the quote is. I get the impulse of like, okay, well, if I'm paying this much money, or if I'm taking something seriously, then I want the person who I'm talking to, or who I'm depending on or relying on to at least show me, some kind of courtesy and respect and whatnot. But then again, I also see the point of like, okay, well, as long as I get the job done, they could be wearing, they could wear a suit of armor for all I care, So I mean, I'll be interested to see like, like what option wins out. But I mean, I can see like sort of like a happy medium, just be like, okay, just wear a dress shirt or like a nice polo shirt or whatever like that, or like, and nice blouse or whatever like that, nothing too fancy. I think this having to wear like a full on suit are probably pointless at this point.
I
I'm a
mean,
big proponent of just blazers. Throw a blazer on over anything and it's good to go and you look professional. That's my thinking.
There definitely is some of that residual lawyerness, right? Where like even when I was a freelancer and I would be on certain interview calls, I definitely, at least from the waist up, dressed up probably far more than other interview candidates for a job interview as a freelancer. But now, even if I'm doing anything that's even remotely, I don't know, fancy is the wrong word, but I'll at least wear like a solid black shirt or something like with you all, I'm wearing like it, at least this is a nice message, but like I wouldn't wear this on like a serious thing, you know?
Well, and that's a good point.
You're
too.
saying we're not a serious thing.
That's in a good way. That means I'm comfortable and I like you all, and I'm taking my vacation time to talk to you all.
I think that's a good point, though. I think a T-shirt with graphics on it is different than just a plain T-shirt. And I also think it absolutely. I mean, if it's a court hearing or trial versus a meeting with a client you've known for a really long time or a status update, that might be. There's different levels of formality even in the practice of law in some ways. I mean, it used to always be a suit and tie, but I think that part of it depends on the situation, the reason you're appearing in an online meeting.
Yeah, and I make a point in, and I link to a study in the article that there's some research that suggests that people trust someone that dresses like them. And so if you're working in a tech space or something like that, where, a bunch of people are wearing hoodies, you dressing up can actually be bad for your relationship with your client. And so to some extent, that's involved, and that spills over to what are they expecting vis-a-vis the difference between a telemeeting and an in-person meeting. I can definitely see if somebody says, hey, let's just get on Zoom, they're probably not expecting themselves to have dressed up. And if that's the case, then maybe you need to. It was a very complex question. I thought it was really interesting.
That was really interesting. I voted for dress shirt or whatever the option was because I just feel like it's a meeting with a client. I don't think a T-shirt would ever be appropriate unless the client was somebody you do really well, and I don't know, whatever. They know you're on vacation and you're taking the call while you're sitting by the pool or something to make a accommodation to them or something like that. But I think as a general rule, a dress shirt does it. I don't think you need to be overdressed. A blazer is good. I keep a blazer hanging in my office for these kinds of calls when I have to do it. But I think a dress shirt pretty much works for the most part.
Actually, a great point. A couple of great points in here. One in the chat that is being raised is about women being judged more harshly, and which is true. Although one aspect of this that I thought was interesting was, I think, while generally true, judged more harshly, I think that men, because there's from the waist up, there's like this suit and tie aspect that people think of. Whereas women have T-shirts, especially if they're not graphic T-shirt without a graphic on them, that look quasi-formal. So there's actually a little bit of slippage where I think women might be able to wear-T-shirts in this setting and still look somewhat business-like in a way that men, because our upper body traditional business attire looks so unique, we couldn't. That was part of when I was talking to some people who had chimed in on this on Twitter, they raised to me that a lot of this is male coded because our gap between a T-shirt and a suit is much greater. So that was an interesting point. And also in the chat, we have a note about the Virginia bar exam, which, yeah, the Virginia bar exam still makes you dress up in a suit to take the exam,
Really?
which, oh yeah, no, this is a well-documented bit of fucking insanity. Yeah, they still make you wear a suit. They make men wear suits and ties, and women have to wear dresses, skirts, or blazers, or pantsuits, and that's a new thing. They didn't allow you to wear a pantsuit for women until shockingly recently, like 15 years ago or something like that. They weren't allowed to wear pants.
Well, I think the point about men and women and the way that they dress, it's interesting because there really is like a uniform for men, male attorneys, right? Like there's a uniform, which is a tie, a button down, and a suit, right? Like that's the uniform that men have traditionally worn. And that's part of what makes it more challenging for women is there may be more flexibility, but there's just such variation in terms of what is acceptable, and it even varies by region, I think, and expectation. It's hard to figure out who are you trying to please and what, like, I had a male partner tell me, named partner in the law firm name when I was a young associate, that I should wear brighter colors because I've always been, I've liked neutrals and I've always liked blacks and whites and neutrals. And he thought I should be wearing, I don't know, hot pink and green. I have no idea, but I wore black the next day just in, opposite, just to be contrary. But, it's hard to, but other people don't expect women to wear color. And so it's kind of hard as a woman sometimes to figure out what you should, how to navigate that. And, but there is more flexibility for sure. And I agree, there's a big gap between t-shirts and button downs for men. 100%. And even short sleeve or long sleeve, like it's got to be long sleeve, I would say, if you're wearing a button down.
And when you start getting into things like color, and then you start getting into like when I used to work in law firm, like I would just wear like slightly longer earrings, and they'd be like, "Ooh, that's flashy." And then there were certain partners, female partners too, that were just like, "Oh, you should really be straightening your hair." And I'm like, now we're getting into all sorts of like even like racially problematic issues, and I'm like, we need to not be policing things that far. I'm like, it's fine. If you want suits, say suits, and then get out of my face, or otherwise just don't. I don't know. I have very little tolerance for the kind of like, I get it. There are certain amounts of dress codes, like of a formality level, fine, but I don't know. I have very little tolerance for wardrobe policing.
Yeah, I think I even might raise this once on this in some other context on this show, but my very first job as a lawyer when I was still in law school, I worked at a clinic where I was representing mental health patients in civil commitment hearings, and we could go into court under whatever the practice, the law school practice rule is in Massachusetts. But the managing attorney of that program that I was working for had this hard and fast rule that male lawyers or male law students, whatever they were to wear a white shirt and a black tie and a very plain suit. And that women lawyers likewise are supposed to dress in sort of very muted, plain. I don't remember exactly what the rule was for the women, but basically his position was that he didn't want your appearance in the courtroom to in any way be an issue for anybody else in the courtroom. He didn't want the judge, any chance that the judge is going to decide a case based on the fact that he thought the lawyer was too splashy or something like that. So I mean that's an extreme position, but I've often thought of that in subsequent years.
I definitely work when I was doing at the white collar boutique. Bunch of the partners were from, even though we didn't do a lot of trials at that point, were from SDNY, U.S. Attorney's Office, being in front of court tradition, and they always preached have one incredibly ratty, almost falling apart suit because that's what you want to wear in front of a jury. You don't want to look like the slick lawyer in front of the jury. Was always their what they had been taught at the office.
With levels of formality addressing, when I was at the public defenders versus when I then switched over to a law firm, I wore pantsuits all the time when I was at the public defenders, and I wore heels, but they were, the equivalent of men's shoes with heels. I don't know if you know what I'm talking about, like suit shoes with heels. And then once I got into the law firm, I felt very pressured to wear skirts and high heels, and that was one of the things I really didn't like about that environment. I mean, the environment definitely changes depending on where you're working and the expectations, and there's definitely a lot of pressure that is unpleasant when you're just there to be using your brain, quite frankly, and that's it's not the only thing that's being considered.
Yeah, like when I was in the DA's office, I think most of us just by default just like gravitated towards like the dark like blues or blacks, or I mean, but there were a few people who like would wear like pink shirts or like pink ties or like things like that, but like they were definitely sort of like in the minority, and then there were they could pull it off. So I was like, whereas like, the rest of us, we were like, yeah, we're not even gonna try that. But yeah, I mean, I think part of it is just, I think it's like what people say, it's kind of the uniform that kind of goes with what people traditionally think of when they think of a lawyer, and like, I guess, I mean, if you do want to look like $1 million in front of a jury for whatever reason, then, there are ways of doing it. But I think for most of us who are like not on a law firm, not on a law firm job, we had to wear the ratty suits just more out of necessity than anything else.
Well, clearly, Joe, you unleashed a hot topic there, and
Yeah, I mean, we've been really kind of trying to be I'm trying to think. I was looking for.
looking
No,
for a
no,
good
I'm
dog
working
pun
on it.
there.
Yeah, I was like looking like working like a bloodhound to find a story. All right, that didn't
Yeah.
work.
We've been like a
Yeah.
pet podcast and a fashion podcast so far. So
Well, someone said Hot Topic just now. It's like you probably don't want to get your suit at Hot Topic, but yeah.
I would
Yeah.
I would have been the Big Law associate in a Hot Topic suit. I was not meant for Big Law.
Yeah, me either. All right. Well, let's see. Well, we could talk about some serious stuff, like Niki. You had a story on something out of California, coming out of California this week, and
Yeah.
I know you also talked about ILTA. You can talk about whatever you want to talk about. How's that? You had a couple of
Well,
stories.
I included my ILTA ABA Journal article, but I feel like we really did rehash. I just included that so people, if they're interested, can read my perspective on ILTACon, but we've talked that one to death, so I didn't want to bore everybody with it. Other than, the only thing I would like to mention is that I really enjoyed using the Simpsons monorail reference as like my theme for that article, and that was fun. And finding some quotes and just watching the video, I love that one. But anyway,
I was actually going to add some more in because I'm our editor on that one. I was going to add some more in, but I'm like, nah, it's no need to overkill it.
but so I amused myself
Keep
with
it
that
on
one.
track.
You too, Victor. But so instead I decided to submit a news story I came across this week that I think is notable, and that's the California legislature. It's heading over to the governor's desk, but there's an AI regulation bill regulating AI that's been passed, and it's interesting and notable because I think it's essential to regulate AI. It's already too late, really. Like the genie's out of the
Bottle.
bottle. Yeah, thank you. Like, where do genies live? I forget.
Genie's out of the doghouse.
The dog's out of the doghouse. That would have been better.
Wait, you say, that now that I think about it, genie bottle is something we always say, but a genie's supposed to be in a lamp, right?
We do,
Like,
yeah.
why do we say bottle?
Genie Bottle, because Christina Aguilera said
Yeah, because
so.
it's a song. Yeah,
Is it?
because
Yeah.
a genie in a lamp doesn't have the same ring to it.
Yeah. Although, was I Dream of Genie a bottle or a lamp? I'm trying
was
to
a
think
lamp.
of the.
Barbara Eden
Was
was a
it?
lamp.
Okay. Okay. All right.
Well, I'm glad we sussed that out. I mean, that's important stuff.
We talk about the serious issues on the show, by the way.
Yeah.
So yeah.
I mean,
Absolutely.
it's a special holiday episode. People know they're never the best.
But so this AI bill was interesting. There's a lot of opposition to it, as you can imagine, because it's California, and that happens to be where all of the, not all of the, but many tech companies are located. And this particular bill, two of the main requirements were that it would require big AI companies to test their systems for safety before releasing them, and also give the state attorney general the power to sue AI makers for serious harms caused by their technologies, like death or property damage, which is clearly they're going down the Terminator or Battlestar Galactica path on that one. But I think it's interesting because a lot of people are like, and I agree, like, we got to do something. We got to regulate this stuff. There's so much horrible potential with these products. But, the opponents raise a lot of good points, one of which is that it's really challenging for AI companies to determine, potential or future harms because of their software, or things that would be predictably harmful, I guess. And then the other is that it's just going to stifle innovation and AI development. And I mean, I think that's true, but I also think it needs to be slowed down. I mean, the potential is terrifying. The fact, and we've talked about this before, but the fact that the people that are developing these tools don't understand how they work, don't understand quite how they're coming to the conclusions they're coming to, don't quite know how to guardrail them on the back end to control them. You know, there's just so much, anyone who dives into sci-fi knows there's so much negative potential. And, you know, I would like mankind to, you know, humankind to be around for a long time. And we got to rein this in somehow. But it's interesting, and it's at least, I thought it was notable that to see that this legislation is passed and is headed over to the governor to veto or not, and just to see how they were approaching it. But I don't think they got it perfect, but at least they're trying and they're moving quickly, all things considered.
I have not read it yet. Has anybody compared it at all to the EU AI Act? Do we know how it stacks up?
I read it quickly today in anticipation of the show, and I just thought it was a terrible bill. I don't know how it compares to the EU one, but I mean it's basically requiring developers of large language models to kind of speculate about all the potential uses that could come out of their you know the technology that they're developing, and provide assurances that none of those will be onerous or harmful. It seems impossible to do. It seems impossible to kind of execute it. I mean, somewhere I was reading, one article I was reading about it was talking about, you know, it's like saying, you know, if you're going to develop a electric motor, you have to think about every which way in which somebody's ever going to use an electric motor. And they're, you know, maybe they're going to use them to drive cars, maybe they're going to use them to drive destructive tanks or weapons of war or something. But you still need electric motors, and you need people developing them and building them. And I don't know. I thought it was really. I just don't see. It seems like it would severely inhibit innovation. I mean, one of the other comments I saw, I forget whether you mentioned this, Niki, is just that it could have a real detrimental effect on open source development of open source AI models. So I don't know. You know, but Elon Musk is for it, so it must be good.
And Nancy Pelosi was against it.
And Nancy Pelosi's against it.
That was kind of
Yeah.
It's a weird, yeah. It was definitely a weird kind of because yeah, it's like I think it's like a Democratic driven build out. Well, it was a Democrat that sponsored it, and then you know yeah. And I mean, who knows how Newsom's gonna come down. I mean, I don't follow him that closely, but just from what I've read about him is like he doesn't always do as what people think he might do. Like I think he vetoed a couple bills like that people were surprised at. But they were in different. Like, I think they were in like yeah, like other things. So yeah. I mean, but it was kind of like one thing I think just reading the article is that like, you know, sometimes with these kind of things, like you want that first bill to come down because then other states or other jurisdictions can then kind of build off of that, so they have a framework that they can then work off of. So you know, I mean, I don't know if this would just be useful in that sense, where it would then allow other states to then kind of build off that and kind of model their, you know, or improve, you know, their bills based on what California does. But yeah, I mean, I guess, you know, it's sort of like, yeah, devil's in the details. And I mean, look, if Elon Musk is for it, then I don't really know how I feel about it.
It should be a good sign that it's not a great idea. He's you know, as I always say, he creates the exploding catch fire version of everything, including his recommendation. Yeah, I looked at it and I was like, look, there might be a need for some kind of regulation, but this dog won't hunt.
That is the only reason.
That wasn't even like a stretch. That actually is the phrase.
I know. I
The
think
only reason you commented was so that you could say that at the end.
That's okay. We're good with that.
Isn't it still I mean, it's a question. I've at least seen some speculation that Newsom might not sign it, right?
Mhm.
Yeah, that's what I've been seeing too.
Yeah.
Yeah.
Well, because look, I don't want to sound like one of the more right-wing conspiracy theory people, but there are right-wing conspiracy theory people who are like, Newsom really doesn't have a thought that Nancy Pelosi hasn't given him, and so she's against it. So here we are.
Well, and also Newsom wants to be president. He wants to be president in the near future. So we also have to see how this is going to weigh on his eventual bid.
And if the last like month and a half has taught me anything, it's the road to being president as a Democrat is, does Nancy Pelosi like your candidacy or not?
Well, and the AI space, the innovation concerns are valid. It's very competitive, and that competitiveness is what is fueling a lot of the innovation. Because it's a dog eat dog world out there. That's the best I can do.
All
Well
right.
done.
Yeah, I think that's good. All right. Well, let's move on to some news about Sarah Palin and her libel suit against the New York Times that has a little bit of a tech angle to it, I guess. Victor?
Yeah, I was trying to come up with a dog pun for this one. I guess it's like a I was thinking about Diderot because it's Alaska, but it didn't come to me quickly enough. So maybe somebody can help me out. So yeah, Sarah Palin got her first victory in a long time. This might be the first thing she's won
You
in
can't
like
teach old dog new tricks.
ah. Um,
You have a
so
tale
yeah,
about Sarah Palin?
was that?
You said you have a tale about Sarah
Yes,
Palin?
yes, yes. The appellate court is keeping the trial court on a short leash apparently, and uh yeah. So well, so basically this is how old the story is. She sued the New York Times over how they covered Gabby Gifford's shooting way back whenever that was. And like because she had the she was targeting certain incumbents for defeat, and she put the crosshairs on like certain vulnerable Democrats, and one of them was Gabby Giffords, and then she ended up getting shot. So then she had that blood libel press conference thing, and then she sued the New York Times because for libel because of the way they covered it, and um so the appellate so the circuit court overturned they overturned the decision in favor of the Times because they found that the New York Times sent out push notifications um, um, covering the story, and then and jurors saw it, and jurors say that it didn't influence them, but the appellate court was like, well, there's no way to determine that, and so it was error not to at least declare a mistrial or whatnot. So basically, push notifications are the reason why this is going to continue for for a lot longer, and yeah, I mean it's interesting because I think it's one of those things where it's like you know it kind of shows just how you know you might not even intend for these things to happen, but New York Times did what they did, to try to get this information out there, and how it affects or could affect jurors. They probably weren't thinking about that at the time, but now it's become a real issue with them. So this is going to drag on. This is going to cost even more money, and it's all because they were desperate for clicks or desperate for views. And so also for all you people out there who don't want to be influenced by these things, turn your push notifications off.
Well, isn't that the thing they're supposed to instruct jurors about in the first place? I mean, I don't know
Yeah.
how the jurors weren't instructed about that, but wasn't this was like a really unusual situation where the judge kind of made a material ruling in the case, but then decided he was going to put the question to the jurors anyway, even though he had already
Yeah,
decided it, and then so the jurors saw the news that the judge had already decided this, and then they were asked to
right.
decide it, and so the idea is they're going to be obviously going to be influenced by what the judge thought.
So
Yeah.
I feel bad for Jed Rakoff on this one, because that actually there's a reason why he did that, because there are procedural reasons why, if you're going to make that decision, you do it beforehand and still let the jury hear it, because if you get overturned on your directed verdict, it can then default to the jury's verdict rather than having to have a new trial. So this came up in the conversation about Eileen Cannon getting the Trump case, because there were some people arguing, like, would she make a directed verdict before it was assigned to a jury or after, because like it affects whether or not it's appealable. So the reason to do that is you say, look, I think directed verdict. Now let's hear what the jury is. Now you're going to appeal my directed verdict, which controls, but if I get overruled, we have something to fall back on. So it actually made a lot of sense and was probably the proper way to handle it. Unfortunately, nobody thought ahead to the New York Times was going to push everyone's phone with it.
Yeah. So he didn't kind of pause to think about the implications there.
Yeah. Oh. Wow. Wow. Well done.
See, my dog came downstairs to take part in the
I
festivities.
get it.
Now she's hiding in the shadows, so you know.
We like to hear your dog's favorite puns. The dog can do some human puns. All right. Anybody else have thoughts on that? Good, just good to hear about Sarah Palin again. It's been too long.
Oh, I'd forgotten about her.
The last thing I heard, well, the last thing I heard about her was that like she ran twice for House, which is kind of sad if you think about it. But then Alaska only has one representative, so I guess it's kind of like a third senator for them. But then she lost like both the primary. She lost like the runoff. Well, no, the special election and the general election. So
Yeah. No,
so
she's
Democrat.
well. So and Jonathan Turley wrote a big thing about this new Rakoff issue, which Turley is, what's the word I'm looking for? An idiot. But he in his thing goes off on how he tries to make this distinction between public official, like Sullivan, New York Times versus Sullivan, he tries to argue is only for public officials, not for public figures. And the fact that she's not currently in office means she shouldn't be hamstrung with the public official protection of Sullivan, which just struck me as so dunderheaded, because it would suggest that you don't get that the political process, which is supposed to be what's being protected, commenting on political process being what's protected by that decision, would only apply if you've won the election. But if you're the challenger, you're outside of that, and everything you say about a challenger is definitely so. All right,
Because you're the
I'm done
underdog.
ranting.
When you're the
Oh
challenger.
yes.
Sounds like she's just chasing her tail.
God, you guys are good.
Yeah, no, she's yeah.
All right. So I just happened to notice that Thorne mentioned in the chat what's going on with Ross v. TR, or TR v. Ross, actually. And it's funny because there was just an order today that came up in that case. But I mean, the trial, I think we talked last week about the fact the trial was postponed at the 11th hour, just as they were supposed to start opening arguments and jury selection and all of that. And then the judge had asked the parties to set a briefing schedule on summary judgment motions. So there's still been some mysterious order from the judge that still hasn't appeared on the docket. But apparently the judge had made some rulings that then took some of the issues that were going to go to trial and reinstated them to potentially being dealt with summary judgment motions, which would mean there's no real issues of fact as to those issues. But it was funny, he put out an order this morning, kind of basically just like approving a briefing schedule on the summary judgment issues, And they've got to get briefs filed by the end of October, and then reply briefs after that. But there was one line in the order that was kind of interesting, where he said, as for the substantive question raised by the parties, though Ross may move for summary judgment on copyrightability and infringement, the court is unlikely to grant that motion, and plaintiffs should not file any brief opposing such motion unless and until the court asks for a response. So in other words, apparently the Ross has gone back to wanting to try and file a motion for summary judgment around the whole copyrightability issue, and it sounds like the judge is thinking that's the part that still needs, there's still going to have to be a trial on that issue, and it's not going to be decided by summary judgment, or not likely to be, unless the judge apparently changes his mind between now and when they file the brief. So, it's kind of a betwixt and between right now, I guess. It looks like there's going to be a trial at some point, but it looks like more of the issues are going to be decided on summary judgment than it was originally looking like. And then there's still the whole other side of the case, the counterclaim for antitrust, which is also being argued in September. That's already been briefed, and that's being argued in September. I think that's still on for argument as far as I know. So that's a whole separate issue where basically Ross is claiming Thomson Reuters has a monopoly. I don't know where they got a crazy idea like that, but that's that. All right. I think we only had one other story on the docket this week. Joe, you had another lawyer AI, not quite hallucination story.
Yeah, which I thought was interesting. Obviously, because I wrote it and then put it in here, so I don't know why I just said those words. Look, we've talked a lot about in the heady days of 2023, we had the situation where we learned that there were a bunch of cases that defended the Montreal Convention on airlines that didn't really exist because somebody decided to use ChatGPT to come up with a bunch of cases and then cite them without checking them. The mainstream media went off on how this was the evils of AI. We at this show largely talked about how that was just lazy lawyering because you should check your sources. So, fast forward to now. There is a new case in Virginia where there's a judge with a show cause motion order about fake cases showing up in a brief. But what was really interesting is the response is we didn't use ChatGPT, we used Lexis and Westlaw. So there's that. But it evinced a new set of problems that are less crazy than making up cases of whole cloth like ChatGPT did, but in a weird way more pernicious, but also, well, not really a reason why you would sanction a lawyer. So in this instance, a few cases were in the brief that were cited wrong. They were just bad at blue booking. Congratulations, they're like a 1L. They put the wrong citation to the case. The cases existed. The cases were real, but whatever happened somewhere in the translation, the AI gave the wrong blank blank WL blank 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 number, which led the judge to thinking that the case wasn't real. So that's a new problem. That said, as the lawyer in defending himself against sanctions wrote, the cases are still real. The cases still defend exactly the substance that I quoted them for. It's just they got the wrong citation. And then the other half of it is there were some quotes from these cases. But the quotes, while part of the actual case, like if you Control F to those words during the case, they would be in there. But they aren't from that case. They're from that case citing another case and having a parenthetical explaining a quote from that other case. And it mixed and matched all those words together. Meaning it was taking the whole document, but it wasn't distinguishing between what was part of the string cite and the parentheticals in the string cite and what was actually the substance of that case, and therefore not citing the actual case that the text is from. Now, is this something someone should be sanctioned over? Probably not. And it's a mistake. It's a problem. It's something that can screw up AI down the road if this got integrated into a case where the judge wasn't quite as on the ball. This would end up in a decision, and then it would train a future AI to quote things wrong. So that's bad. But one of the points that I thought was really interesting about the story was the lawyer made the point, we literally would make this a human makes this mistake all the time, and nobody ever asks for sanctions. They always shrug and go, yeah, sorry, your 1L, your first year screwed that up. But now, because it involves a technology, everyone is hypersensitive and making show cause orders and trying to get sanctions and trying to be that guy or gal. But weirdly, I have not yet seen a woman judge do this. Maybe I've missed it, but I've only seen male judges be like, we got to stop AI, whatever that means. So I thought it was really interesting that they made that point because, yeah, I've been in many a hearing where somebody goes, oh, yeah, right, before we move on, I just want to point out we said not here. That's not actually what it is. Or we actually had the wrong quote. And everyone just shrugs and moves on with their life. But now, show cause orders, more briefing, more court time wasted on it. And for what?
I'm just curious, just the pure curiosity. Did they say, yeah, this was an AI mess up, or, oh, we're just really bad at blue booking and research?
Yeah, no, they said this was an oversight on their part, that they didn't catch it. But yes, the AI spit out this, and they didn't catch it because, and this goes back to the first year problem. They read the actual case. They're like, the actual case is right, because the system, and this is a part where ChatGPT wouldn't do this, but a more integrated into a legal research platform might.
Yeah.
It gave them the actual case, and they were like, we've read the case. The case is right. We know the case. What's the cite to that case? Oh, it's this. And it was not correct.
Oh, yeah, I'm not disagreeing with your point. I was just curious. They had.
Oh, no, it's a good question. Yeah.
Well,
That's actually one. Go ahead. I'm sorry.
Oh, no, that's okay. Go ahead. I'll save mine. Okay.
Go ahead. Well, I was just going to say, I mean, that's one of the things that came up in that whole Stanford study when it was sort of describing the kinds of hallucinations in Westlaw and Lexis, where it had the right case, but the citation was wrong, or the quotation was wrong. And those are very specifically examples that came up in that study. And those are kind of the things they digged as, I forget if they included those as hallucinations or not, but that was one of the dangers they found in using these platforms.
A real quick thing on that is I find that AI is weirdly, for a computer program, weirdly messed up about numbers. If I say, hey, I want you to give me 6, blah, 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 it's like, here's 19. And I'm like, but that's not 6. It weirdly has a struggle with numbers. And I could imagine blah, 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 F third is a thing that they get tripped up on.
Another way, it's like lawyers.
Right. There's two things that are sort of separate, but related. So the first is in regards to what you just said, Bob. So what are the lawyers supposed to do? Is it supposed they should have to go to traditional Lexis or traditional Westlaw and search for the case and get the citation there? Is that what they need to do to avoid the issue? And also clearly read the case to make sure the quote came from the case and not from a case cited within the case. But in terms of the citation, do they have to backtrack and go to the traditional legal research site to confirm the actual citation? That's a lot of extra clicks and back clicks and whatever. So that's an interesting issue. And then the other thing is, in terms of the what I would call a knee-jerk reaction to tech, that's something like I've been complaining about forever, and I'm obviously not the only one, but is the ethics committee's knee-jerk reaction to tech. They do the same thing as the courts are doing in this situation. Oftentimes I find it crops up in the ethics opinions, anytime there's new tech, suddenly you need client consent to use it, from like email to like the cloud to now AI. Like they always want like client consent, and eventually it just becomes the course of business. And suddenly you don't have to get client consent anymore. And that's just this thing that we did when we were all being ridiculous and knee-jerk reactions to tech. And it feels a lot to me. I think that lawyer raised a really good point, and I agree with him that that particular reaction here of sanctioning everybody and making a big deal and wasting everyone's time is absolutely a knee-jerk reaction to this tech.
Or what
They
lawyers
need
will
clear
just do is
brief.
they'll just be like, next time they get called to the carpet on this, they'll be like, oh no, sorry, my intern messed up and we just missed it. So rather than so just keep AI out of it, and that way everyone, like Joe said, everyone just shrugs and says, all right, well, shit happens, and then everyone moves on.
There are any number of products out there that can check citations in a brief as you're drafting them. Roberta's noting a couple of them in the chat, but doesn't ClearBrief do this as well? I think can check the citations and the quotations that you have in a brief.
But
And
still, if
there
you're
are definitely products that do
using,
that.
if you're using Lexis plus AI or Westlaw with co-counsel, or whatever their, the legal research functionality is built into Westlaw. I don't think it's actually co-counsel. It's just their AI capability. But, you would think that you could just rely on the site. I mean, clearly you can't. But so it requires, and if you're going to use the AI, it requires an extra step to go. You can't confirm that, you can't rely on that tool, at least it would appear so, to properly cite stuff for you. So
I think you can though in Westlaw. I think when it gives you an answer, it may have the site wrong, but I think you can always click through to the full text of the case, which I would imagine would have the correct citation on it. I can't imagine it. If you click through to the case, it's going to be wrong. I don't know. Maybe I'm
sounds
wrong.
like they did that. They clicked through the case and read it.
Yeah, like it gave the case. And this is that like weird AI doesn't get the numbers right. It knows what the thing is. It just tells you the wrong thing.
But they could have read the case and just assumed it's Westlaw. It's got the citation right, and I don't have to check
Yeah.
that or something. I mean, they might have just not thought to check that.
Like,
Yeah.
how did we do
Yeah.
all this before? Like,
How what?
we did all this before, like 15
Well,
years ago. Then
AI.
somebody wrote a brief. I made sure I was turning it in, that I wasn't citing
Right.
a parent
Right,
that
but now,
was not a quote. Like, I mean,
I used to do that
right,
too.
but
At the end,
but
go through
now,
everything.
yeah. Oh, absolutely. But now what we're dealing with is a situation where the actual product that we used to
Oh no.
I love when he freezes in great poses like that. I never.
That was gonna be so good too. I
Oh,
could
he's
tell.
not freezing.
products
Yeah. Oh,
that we trusted to do that. What'd you say?
You
thank-
froze.
You
for a
froze. We
while.
were trying
I
to take a
froze?
picture while you froze. Yeah.
Oh, amazing. Okay. So, but now the actual products that we historically have trusted to give us the answers that we then check with are the ones telling us something.
Yeah,
That's different than choosing Chat GPT and being like, oh, I trust it, No. Can I hear
Yeah.
anybody?
I just
Oh.
don't have a lot of sympathy, I guess. That's where I fall down.
Oh, shepherdizing.
That's
Oh,
a good one, right? I was
nice,
just looking at that one
nice.
too.
That was a good
All
one.
right. I think
Yeah.
Mark takes the prize.
Yeah.
He gets to embark on Labor Day weekend. Embark on Labor Day weekend. With
Oh, that was a good
Oh,
one.
that wasn't even a thought of one. Anyway. All right. Well, yeah, there was anything else on that before we kind of wrap up? It's kind of the dog days of summer are coming
I
to
was
an end.
about to say that.
Ah,
Actually, technically, I think the dog days of summer
Oh,
ended a
what are
few
you
weeks ago. But anyway, we'll go with that.
Legal
Oh
site.
yeah.
uh,
All for P-Doom.
I will say or I don't know about that. I was just gonna say, for Labor Day, it is worth at least mentioning, sometimes participant in this show, Steve Lerner, Law 360 is going on strike immediately after Labor
Oh,
Day.
that's right.
So
That's right.
worth noting for people that the writers, and I guess this is LexisNexis owns them. Anyway,
Yeah.
worth noting that's what's happening.
That's right too. I forgot about that. Well, I wish them success in their negotiations. I'm not even sure what the issue
P-Doom.
is. Do you know what the issue is?
I mean, just everything. It
Money,
sounds
everything.
like.
Okay.
It just sounds like a
It
lot.
could be any number. It could be any number of things based on what. Yeah.
Yeah,
All right,
I
well,
mean,
yeah.
I read their statement. It seems like a lot.
It's like everything has gone to the dogs.
Yeah, they've been hounding LexisNexis for an answer on this for like 2 years now.
Yeah.
I don't know if we can do P Doom after all this. We can do a quick P Doom. All right.
Yeah, just
Who wants-
numbers. Let's go.
Numbers. Go, Joe, go.
25?
Okay.
Yep.
Nikki?
32 because of the puppy. I have to put some words in there. I'm happy. I feel positive about the future.
All right, Victor.
Yeah, let's go with 25.
All right. Stephanie, you're on vacation. We
I
gotta have a
know.
good-
I'm like 10. I'm on vacation.
0.
All right.
I'm in
Alright,
Florida
so-
though, so I get 10.
All right.
Oh, yeah.
All right. Yeah,
Sorry,
I'm doing like a 20. I'll give it 20 this week. So we're all in a
Wow,
relatively good
I'm
relatively
high.
good place.
I'm still the
Yeah,
pessimist
yeah.
of the bunch, I guess.
Yeah.
Good.
Yeah.
All right. Well, I hope everybody has a great Labor Day weekend, and thanks for spending your Friday afternoon, if depending on where in the world you are right now, your Friday afternoon with us. And see you next week.
Well.
Well.